Thank you, Professor. Esteemed professors, dear guests, dear colleagues, first let me tell you that it is my great honor and pleasure to be able to present at this conference, and also I would like to thank Professor Szilágyi for giving me this opportunity. The topic of our presentation is the role of criminal courts in prosecuting environmental crimes in Visegrád countries, Poland, Czech Republic, Slovakia, and Hungary. Generally speaking, environmental crime is an area which has until quite recently been largely neglected throughout the world. However, this started to change in the past few decades with a growing global awareness of endangerment of the environment. That change has also been present in the countries of Central Europe. The reaction of criminal law on environmental crimes in all of those four analyzed countries is quite similar, as we have already seen in previous panels. Therefore, this presentation will have a synthetic character. It will be divided into three main parts: substantive or material criminal law concerning environmental crimes, then the issues of law of criminal procedure, which are particularly relevant for this area of criminal, and concluding remarks. First of all, when it comes to substantive criminal law on environmental crimes, the first question that we're going to address is the subject of criminal responsibility. In the first panel, we already had something told about this. Well, criminal law traditionally limits criminal responsibility to individual criminal responsibility of natural persons. However, relatively recent developments witnessed the introduction of criminal responsibility of legal persons or legal entities, for example, companies, which can coexist with criminal responsibility of natural persons in the same situation. All four analyzed legal systems prescribe the possibility of legal persons or legal entities to be criminally liable also for environmental crimes. However, in all four countries, very rarely are legal persons indeed held accountable or liable before the court, and therefore proclaimed to be criminally responsible for a certain environmental crime, although this is generally the case with criminal responsibility of legal persons, not only in the area of environmental crime. When it comes to some particular issues of the general part of criminal law that are relevant for environmental crimes, the first problem is the problem of causality, the causal link. It is, of course, relevant only in relation to so-called consequential crimes, the crimes which require material consequence to occur. For example, a specific environmental crime requires that some kind of environmental damage has occurred in the concrete situation. It is generally challenging to establish and to prove the causal link between the acts or omissions of the accused and the environmental damage which has occurred. Just a second. The problems in the field of guilt are the second main issue we have identified, mens rea. By far the most of the acts that could be subsumed under some of the environmental crimes are in reality committed not intentionally, not in dolus directus, but rather negligently. This has two major repercussions. First, it is very difficult to convict a person for an intentional environmental crimes, especially for dolus directus. And second, conversely, as most of the environmental crimes are committed negligently, penalties for these crimes cannot be too high, cannot be too serious. Then when it comes to some issues in the special part of environmental criminal law or specific environmental crimes, in criminal codes of all of the four analyzed states exists a special chapter prescribing environmental crimes. That is chapter 22 of the Polish Criminal Code, chapter 6 of Slovak Criminal Code, chapter 8 of Czech Criminal Code, and chapter 23 of Hungarian Criminal Code. This means that environment has been recognized as a very important social value which deserves to be protected by criminal law as such. Nevertheless, in all those countries, there are, to a greater or lesser extent, various environmental crimes that are contained in some other sources of law, some other legal acts, not only in the criminal code. In all four analyzed systems of criminal law, a sort of general environmental crime exists. For example, the crime of damage and endangering of the environment contained in the Article 293 of the Czech Criminal Code. Besides this general prohibition, the legal systems of those four states further prescribe a relatively large number of other more specific environmental crimes, which deal, for example, with specific way or method of endangering or damaging the environment, or with the a specific kind of environmental damage or with the protection of a specific part of the environment, for example, soil, air, water, and so on. Also, a significant number of environmental crimes, formally environmental crimes, are dedicated to the protection of animals. When it comes to penalties, criminal sanctions, in all four legal systems, various penalties could be imposed for those crimes, ranging from fines, financial penalties, to imprisonment. However, in practice, the fine is still seems to be the predominant penalty. Some other forms of alternative sanctions or sui generis measures are also specifically present in this field. For example, elimination of damages is very important in this area. When it comes to the law of criminal procedure and some contentious issues in relation to environmental crimes, the main issue are the evidentiary problems of evidence. As already it has been told in the previous panels, some elements of environmental crimes, for example, causal link or intent and so on, are per se as difficult to prove. However, given the specific nature of this kind of crimes, they could, in general, be considered challenging in the field of evidence. Due to the general lack of knowledge about environmental issues, in practice, the key evidence when it comes to the environmental crimes is being provided by expert witness. Although formally none of those four analyzed countries contain in its legal system a rule which prioritizes formally this kind of evidence, but in reality, it is the main evidence in criminal proceedings. Also, the lack of specialization, or at least lack of additional education of official subjects of criminal proceedings, that is, police officers, public or state prosecutors, or judges, on the matter of environmental issues, is listed as a major problem in all four countries, although there exist some differences in relation to them. Although there have been some improvements in that field as well, already it has been mentioned, the specialized Department of Detection of Hazardous Materials and Environmental Crimes, so-called Enviropolis, was created in Slovakia in 2022 within the police force with a nationwide jurisdiction. When it comes to statistical data provided in those four articles in analyzed states, the general impression is that environmental crimes are being under-prosecuted in all four countries, although the situation is slowly getting better. For example, in Czech Republic, statistical data indicates that Chapter 8 crimes represent a relatively small portion of overall criminality addressed by the criminal courts. However, their share in relation to natural persons, not legal entities, has slightly increased over the past 6 years, with the exception of 2020. When it comes to some concluding remarks or conclusion, generally it could be concluded that the legal normative framework of criminal law in all four countries when it comes to environmental crimes is satisfactory. That is a general conclusion. This is especially the case with special part of substantive criminal law. All four analyzed legal systems contain a relatively large list of concrete environmental criminal offenses. However, there is of course always plenty of room for various improvements. For example, in all four analyzed countries, it is possible and advisable to strengthen existing programs of education, as well as to introduce new ones in the area of environmental crimes, especially in relation to the official actors of criminal proceedings. Also, as it has been already mentioned, it is imperative to follow the developments in the EU law in the field of environmental criminal law, as all four countries are member states of the European Union, as well as in the field of environmental law in general. And this famous directive, has already been mentioned, Directive 2024/1203 of the European Parliament and the Council, which prescribes new criminal offenses, relatively new criminal offenses, and all countries should correct their legislations according to it. However, when using criminal law as a tool for protection of the environment, one must always bear in mind its ultima ratio character. It has already been reiterated several times today. Criminal law is the last resort, the most severe kind of legal reaction to the most serious damages or endangering of the most important social values. Although the environment is undoubtedly recognized as one of those values, only its most serious infringements should be dealt with criminal law. Therefore, it seems that the other branches of law For example, administrative law, which will tomorrow be addressed if I'm correct. For example, inspections that operate under the rules of that branch of law, which represent the first line of legal defense of the environment, should be strengthened as well, and that only when they are unable to deal with a certain more serious issue, criminal law should step in. Thank you for your attention. I think I was before the bell, so
thank you very much for the floor. Yep. Okay. So, dear ladies, dear gentlemen, I will start with a second question from the end. The former UK Prime Minister from the second half of the 19th century, Benjamin Disraeli, told that we have three types of lies: dominant lies, and statistics. So, and Winston Churchill corrected it a bit this speech from Disraeli, that he is believing only that statistic, that he changed that for himself. So that's why not many statistics from me, but I will say that the Czech Republic, the Czech courts, criminal courts, receive every year about 75,000 criminal cases, so charges. From them, but are only about 100 charges about the environment crimes or criminal offenses. So it is not very much. It is 0.1% of every criminal offenses that we have to deal. And that's why it is not so many cases. And I mean the sentencing in these cases is not lenient, because mostly it is suspended in imprisonment, or then the second most used penalty is the financial penalty. So that's why I mean it. But it depends from many circumstances which one penalty should be, or which one sentencing should be given to the defendants. That's why I mean it is no problem with the sentencing, that it is not lenient, it is not strict. It is every case is originally every case has different circumstances, and that's why the sentencing, I mean, is correct. So I don't have a problem with that it should be more strict, and it depends which one case it is about, because I can't imagine that because of the, for example, for the poaching, should be someone sit in a prison for, I don't know, many years, yeah. So it make no sense. And about the specialization, we have police officer, they are specialized for the environment crimes to investigate that. We have prosecutors, they are specialized too to deal with the environment crimes. But by the judges, it's just a bit differently. The judge, we don't have this specialization between the judges. We have another specialization, for example, for the juvenile or for another one, but not for environment crimes, because of the amount of this type of crimes, yeah, what we have to deal, and I don't think so that we need something like this specialization, because it is not so much so many cases, and each judge have to educate himself. So if I get a case which I have to deal, and it is about environment crime, I have to learn everything around that. If I get any case with for example, another type of criminality or crimes, so I have to know everything about that I can assess everything, and then I can decide in this case. So that's why I mean it is not necessary to make a specialization for environment crimes by the judges. And it's true that the prosecutors and the police officers, they are specialized for this type of crimes. They mostly are investigate another criminal offenses, because there are not so many of them. For example, what the education and the self-education for the judges, we have an amendment of the law about the courts and the judges, and it will be a step come into effect from 1st of January next year, that each judge have an obligation to submit the president of the court his plan for education for 3 years in advance. So for the next 3 years, and if he has interest, or if he think that he has to have any education in this area of environment, the Judicial Academy will of course make different plans and different topics, with different topics, the seminars in the environment crimes too. So it is it is a way how to the self-education make more broader. So that's the answer for the questions. Thank you for your attention.
I'd like to say thank you for the opportunity to that I have to share with you my observation. And maybe surprisingly, or maybe not, I'm environmental lawyer, not criminal lawyer. So I think that my point of view is quite particular. First of all, my colleague Marcin said a little bit about codification of criminal offenses in Poland. And actually, I think I put it that way. We have quite of problem with that. Not very big, because we have, I think, very wide codification of environmental crimes. But the problem is that it is divided. It is divided in the criminal code and outside. And what we have in criminal code, we have chapter 22, 9 articles, plus 2 articles which are placed in different parts of the code, but they talk about criminal environmental crimes. And what else? We have Nature Conservation Act, when we put the criminal offenses, then the Act of Alien Species, then the Hunting Law, then the Water Law, then the Geological and Mining Law. It's not enough. 15. This is the number of different acts that contains criminal crimes, environmental crimes. Why it is not a good solution for environmental protection? First of all, the material is very huge, fragmented into many pieces. Too many pieces, and it makes difficult for judges to implement in a soft way the articles. As my colleague said, we don't have also in Poland specialization. So criminal judge, it is criminal judge, and one case is a case of property theft, another is environmental case. When we are talking about the environmental cases, they are quite difficult. And from the state point of view, it is very important to facilitate the judge their work, which, as I mentioned before, is really difficult when we are dealing with environmental cases. And I think that it is also important to have one codification from the society point of view. Why? Because it is easier to get to know what the criminal offenses is and what is it. Usually, now we live in a very fast world, so we are used to have very short and brief information and complex one. And when we are talking about environmental crimes, we have to check many acts in order to get to know the full picture of the environmental crimes. And it is also important when we are talking about the legislation. Why? When we want to change criminal code, we engaged a lot of criminal lawyers. So they have the opportunity to look at the proceeded act during the legislation process, and they have the opportunity to prepare, to redact the article in the best way. And it is also important later at the stage of implementing, of using this article. Once again, we are going back to the nature of environmental cases. They are very complex. And during, when I was coming here, I talked to Kristina, Hungarian prosecutor, and she said that the most difficult part of her work is to collect evidences. So having very clear legislation really helps at the later stage to have very strong and criminal protection when we are talking about the environment. And this is the first question. The my second answer will be shorter, because I think that I can fully agree with the professor. So, first of all, why we need specialization? I agree that we don't have enough cases to have environmental judges, but environment cases are really complex. And it is really good to have a person with a good knowledge to carry on these cases. The nature of evidence, which I said before, it is very complex. And interdisciplinary character. It was said here in a previous panel that opinion from the specialist, you have to wait for that. And then from the judge point of view, when often he deals with that kind of opinions, it is easier to interpret and then to have the final good decision. And effectiveness of law enforcement. When we have well-prepared prosecution, when we have well-prepared judge, we can be sure that our environment is protected also well. Thank you.
Good afternoon, ladies and gentlemen, Mr. Professor. Thank you very much for opportunity to make in Budapest presentation in this conference. All my life I am criminal lawyer. I was 30 years prosecutor and 22 years in General Prosecutor's Office of the Slovak Republic. And in my point of view, it's most important cooperation, for example, in these activities on the Enviropolis and Prosecutor's Office, because this cooperation is the beginning of criminal proceeding. Regarding to the professional level of investigators or other member of the given department, is necessary to state that they represent a specialized unit and they are trained at regular intervals for various situations. They may arise in the case of the environmental crimes. In order to operate effectively, members of this police are properly and regularly trained. They undergo deployment training for various situations, such as the use of hazmat suits. In the context, the material technical support of this unit cannot be overlooked, from specialized off-road vehicles to various drones. Currently, the unit in question is equipped to such an extent that it is able to carry out the vast majority of technical operation independently. For example, without the intervention of a third party in the form of the private specialized company. Waste dump with drones flying over the chimney in order to measure substances. Our knowledge about this specialized police force, it's very good cooperation. They have many criminal cases successful. But problem in our condition in the Slovak Republic is criminal proceeding, because it's too much or too many formal, and it is problem when we began investigation against perpetrator. Please, you can continue.
Thank you. So first of all, I'm also very honored to be here and very glad that I can answer the second question, the general question. So regarding the specialization of the subjects of the criminal proceedings, as Professor said before, he talked about the Enviro Police. So we have this special department of police, but I will not talk more about that. I will focus on the specialization of the prosecutor's office and the specialization in the judiciary. So regarding the specialization of prosecutor's office, the specialization is ordered directly from the prosecutor's general office in Slovakia, while each district prosecutor's office must have at least one specialist for the specified criminal activity, to whom the specified criminal offenses are subsequently assigned. In the conditions of regional prosecutors' offices, a specialization is also given to one prosecutor, who subsequently supervises subordinate specialists. There are two specialists working at the General Prosecutor's Office in Slovakia, who subsequently handle the supervision agenda, which in Slovakia is mostly the extraordinary remedies in these cases. Specialization is subsequently deepened through annual meetings of the General Prosecutor's Office of the Slovak Republic, which include also the participation of the members of the police force of the aforementioned department. So in relation to so-called the judicial specialization, we think that given the specificity of the agenda in question, it is not necessary, but it would be very beneficial to the criminal proceedings. The form of its implementation is rather questionable, but perhaps the most effective way would be to determine the subject matter jurisdiction of the court, to hear the criminal activity, the environmental criminal activity in question, in the form of a specialized district or a regional court. Well, in this way, it would be possible to further educate and specialize at least one or two judges who would be assigned the criminal cases in question. So this is justified mainly by the specificity of the agenda, of the environmental agenda, because as my previous colleague from Poland said, it is the same in Slovakia. The most of the provisions of the offenses in the Slovak Criminal Code represent the so-called blanket norms, blanket legal norms that refer to relatively demanding special regulations in the field of administrative law. For example, the Waste Act or the Act on Environment or other special legislation that is very vast and it is very beneficial to have a person that is educated in this field to deal with environmental cases. So this is everything from our part. Thank you.